I was about to tell you, the night before we do an event, people, whoever wants to, can meet at my house at 5:30 and have a drink in a lamb chop. And you start talking. Last night, there turned out to be 14 people, including us, and we had one heck of a conversation based on freedom of speech, the First Amendment. Samantha Barbas is a professor of law at the University of Iowa. I met her when I was in Aspen Institute this summer, and I said, oh, is she smart. She is an author of numerous books on the media and history, with a focus on journalism, privacy, defamation, and the First Amendment. She's written a book about the case in 1984, Sullivan versus the New York Times. I have the right name?
1964, New York Times.
1964, New York Times.
Yeah.
It changed for us with that decision. So I would like to introduce you and definitely ask questions, because there's one thing that concerns me, which I talked about with her in the car, is that we do have freedom of speech, supposedly, but then you get attacked by powerful people and you have to go and hire lawyers to protect your freedom of speech. So do we have freedom of speech?
Thank you. Thank you so much for that introduction. I really appreciate it. So I'm a legal historian, as Dale mentioned, and I focus on the history of freedom of speech. And so what I want to do today is to talk about the making of freedom of speech and press in the United States. So telling you about the entire history of freedom of speech could take up your whole day, could take an entire week. So I'm going to focus on one small but very important part of that story of the making of free speech. I'm going to be talking about one Supreme Court case that's widely regarded to be the most important First Amendment case in history. And I think it was absolutely critical in setting up the broad speech and press freedoms that we enjoy today. And so this Supreme Court case is not only historically important, but it's also really important because there's been a lot of controversy around it lately. There have been many who have argued that this case, called New York Times versus Sullivan from 1964, should be overruled. So New York Times versus Sullivan is a case about freedom of the press. It's also a case about defamation law. And there are some who say, well, it's too easy for the press to defame people and to get away with it. And we need to have a stronger law that holds people accountable when they inflict injury to a person's reputation. But there are others who say, well, laws of defamation that are too strict have a very chilling or restrictive effect on freedom of speech, and that is harmful to democracy. And so this issue of New York Times versus Sullivan and defamation law and freedom of the press, it's been really contested in recent years, and there have been a number of efforts by various groups to try to get the Supreme Court to overrule New York Times versus Sullivan. So I'm going to talk about some of those recent developments and challenges at the end of my lecture. But what I want to do right now is to tell you the story of this landmark case from 1964, New York Times versus Sullivan. And I wrote a book about this case, and I think the story is so interesting and exciting because it reveals how freedom of speech in America isn't just something that was invented by judges. Freedom of speech isn't just an idea that lives out there in the Constitution. Freedom of speech was created by people. It was created by people on the ground. It was created by lawyers and judges and social movements, and in particular, in my story, the civil rights movement. So again, freedom of speech, it's a constitutional idea, but it has to be sort of lived and enacted and fought for on the ground. And in my story, the civil rights movement was a major player in the creation of free speech. Martin Luther King, Fred Shuttlesworth, civil rights activists were also very important players in the history of free speech. So with that, I'm going to launch into my talk about the history of this 1964 decision, New York Times versus Sullivan, and why it is so critically important today. So first, I'm going to be talking about how this case came into being and how it grew out of the civil rights movement. Then I want to talk about how the Supreme Court decided the case, why it decided the case as it did, and then I'll discuss Sullivan's enduring impacts on journalism, freedom of speech, and American culture, and why this decision matters so much today. So I want to start by talking about the legal issues in the Sullivan case. New York Times versus Sullivan dealt with libel. So as you probably know, libel is a civil cause of action that addresses injury to reputation caused by a false and defamatory or reputation-harming statement. So under the law of libel, someone who claims that they were defamed, someone who claims that their reputation has been hurt by someone's false statement, can sue and potentially recover a monetary damage award. So under the rule of New York Times versus Sullivan, as a matter of First Amendment law, a public official suing for libel must prove that the defamatory statement was false and that the speaker made the statement knowing that it was false or with reckless disregard of the truth. And so this rule, which is called the actual malice rule, provides broad protections for speakers. New York Times versus Sullivan transformed libel law and also First Amendment law. So libel law is very old, dates back to medieval England. But the story of New York Times versus Sullivan starts in the middle of the 20th century. And there are many possible starting points to New York Times versus Sullivan. One is 1947. So in 1947, civil rights activism was taking off in the South. And in that year, the managing editor of the New York Times, a man named Turner Catledge, made a historic decision to put New York Times reporters full-time in the South. And so the New York Times was then, of course, the nation's newspaper of record, and it became the first national news outlet to have a Southern bureau. And the purpose of this was to cover the burgeoning civil rights movement. So the New York Times soon came to be regarded as the nation's most comprehensive source of news on civil rights. In 1954, when Brown versus Board of Education was decided, the New York Times was the only national news outlet covering the South. 2 years later, by the time of the Montgomery bus boycott, most of the major news outlets in the country had followed the New York Times and put journalists in the South. Well, segregationists reacted with great hostility to this influx of Northern reporters. They feared the power of the press to influence public opinion with good reason. In the 1950s, the mass media were more influential than they had ever been, right? More Americans were reading the news than ever, and television news was going straight into Americans' homes. So media coverage of civil rights protests and the violent backlash that those protests generated would prove critically important in building national support for civil rights that led to the Civil Rights Act of 1964. So quite simply, the civil rights movement needed media coverage. Civil rights movement needed the New York Times, NBC, and CBS. Images of civil rights activists being attacked by police, pictures of neatly dressed protesters being ejected from segregated lunch counters would illuminate for the whole world the cruelties of the South's racial system and the courage of those who defied it. By 1956, segregationists had embarked on a large-scale campaign to resist integration that was known as massive resistance. This included the passage of laws to forestall integration, outright violence against civil rights activists, and also attacking the press. So the segregationists waged a fierce war on the national press to intimidate it and to deter it from covering the civil rights movement. So reporters who covered civil rights protests were beaten and assaulted. Cameras were smashed, Another weapon that was used against the press was libel suits. So the segregationists realized that high-value libel lawsuits could be used to threaten and to terrorize and even to bankrupt media outlets that covered the civil rights movement. So I'll say something about libel law. So libel law was traditionally very strict. It was weighted in favor of the plaintiff, the person bringing the lawsuit. And this reflected the high value that historically was placed on a person's reputation. Right? We've always prized our reputations. A good reputation was often described as a person's most valued possession. One way that libel law was weighted in favor of the plaintiff was that it was judged under the rule of strict liability. So this meant that a speaker or publisher could be liable regardless of their fault when they made the statement. So a statement that was false and defamatory and that someone made innocently could still subject them to liability. Before New York Times versus Sullivan, a person suing for libel didn't have to prove that the statement was false. The falsity of the statement was presumed under the law. The only way that a publisher could defend a libel suit was to prove the truth of the statement completely and in all its particulars. This is very difficult, right? Even if a statement is in fact true, proving its truth completely in a court of law is a very daunting task. So as a practical matter, libel laws affected freedom of speech. A newspaper's decision whether or not to publish an article might well depend on whether the newspaper had reason to believe it would be sued for libel. Even though libel laws affected freedom of speech, the Supreme Court said repeatedly before 1964 that libel law did not raise any First Amendment issues. False and defamatory statements were said to be unprotected by the First Amendment because they had no social value. So prior to New York Times versus Sullivan, there were no First Amendment protections in libel law. This meant that a newspaper that published criticism of a public official, one who was litigious and who wanted to retaliate, might find itself on the losing side of a libel suit if it published an innocent mistake or even a true statement, if the publisher couldn't prove the truth of the statement completely. Now, this didn't mean that newspapers couldn't publish. Big newspapers like the New York Times found ways to prevent and to defeat libel claims. New York Times used specialized attorneys, it conducted extensive fact-checking, so the Times could publish somewhat freely by taking these precautions. Nevertheless, libel remained a formidable latent threat to the press, as the New York Times would discover. So another starting point to the New York Times versus Sullivan case is February 1960, when 4 college students sat in at the segregated Woolworth's lunch counter in Greensboro, North Carolina. This courageous act ignited a sit-in movement across the South that became the focal point of national attention and a catalyst of major social change. So the sit-in soon reached Montgomery, Alabama. And in Montgomery, 35 students sat in at the segregated lunch counter at the Montgomery courthouse. These protesters were attacked by mobs. 39-year-old police commissioner L.B. Sullivan, the man in the suit, supervised the police. He permitted these mobs to attack the protesters while the police just stood back and watched. Not long after this, the civil rights movement faced another crisis, and this one involved Martin Luther King, who was by then leader of the civil rights movement and head of an organization called the Southern Christian Leadership Conference, the SCLC, which focused on grassroots organizing and mass demonstrations as a way of drawing attention to civil rights. Alabama authorities had brought up Martin Luther King on phony charges of tax evasion. Governor John Patterson of Alabama had engineered these charges as a frame-up, basically to remove King from the leadership of the civil rights movement and to bankrupt his organization. So not long after this, a group of civil rights activists in New York held a meeting to try to brainstorm a way to raise money for the defense of Martin Luther King and also for the defense of these civil rights protesters who were attacked. And so this committee, which was called the Committee to Defend Martin Luther King and the Struggle for Freedom in the South, they planned a number of fundraising rallies and concerts, and they also took out an advertisement in the New York Times. So this is the ad which became the basis of the lawsuit in New York Times versus Sullivan. So this full-page advertisement described an unprecedented wave of terror that had been visited on the civil rights protesters by, quote, Southern violators of the Constitution. So it described the abuses of the Southern police against civil rights activists. It talked about students in South Carolina being ejected from lunch counters and tear gassed. It described how in Montgomery, protesters were expelled from school and how truckloads of police armed with shotguns and tear gas ringed the college campus, again, to terrorize these protesters. So this full-page ad ran in the New York Times on March 29th, 1960. And the title of the ad was Heed Their Rising Voices. And listed at the very bottom of this ad were the names of many important figures in arts and politics at the time. Marlon Brando, Frank Sinatra, Eleanor Roosevelt were listed as endorsers of this statement. And at the very bottom, there were the names of 20 ministers who were leaders in the civil rights movement in the South. They were associated with the Southern Christian Leadership Conference. And so this ad was written very hastily, and it contained a few factual errors. Most of them were minor. One mistake, the ad said that the student protesters sang "My Country 'Tis of Thee" on the steps of the Capitol when they really sang the national anthem. The ad said that Martin Luther King had been arrested 7 times by Alabama authorities when he was only arrested 4 times. The most serious mistake in the ad was that it said officials had padlocked the dining hall of a local college to starve and to punish civil rights protesters, and that was not true. The New York Times didn't do its usual fact-checking. Usually the Times checks everything that runs in the paper, including advertisements, but it didn't check this ad because it was so impressed with the famous signatories. So there were, in fact, a few mistakes that had crept into the ad. So what happened next was sheer serendipity. 394 copies of the New York Times were circulated in Alabama. And one of those copies happened to go to the editor of the local newspaper, the Montgomery Advertiser. Editor Grover Hall had a long-standing grudge against the New York Times and the Northern press. He believed that they were treating the South unfairly, and when Hall saw this ad and he saw there were some mistakes in it, he recognized a brilliant opportunity to sue the New York Times for libel. So under well-established libel law, the New York Times was just as responsible for this ad as the people who created the ad. So Grover Hall and a 37-year-old attorney named Roland Nachman on the left encouraged 3 Montgomery officials, including L.B. Sullivan, to sue the New York Times and 4 leaders of the Southern Christian Leadership Conference who had endorsed the advertisement. These Alabama officials said that the ad defamed them because it accused them of being complicit in brutality against the protesters. Now, none of the officials were mentioned by name in the ad. The ad talked only about the police and authorities. Moreover, it's unlikely that a Southern official's reputation at this time would have been harmed by an accusation that they were engaging in brutality against civil rights protesters. Nevertheless, under existing libel laws, all the plaintiff had to demonstrate was that the statements had the potential to injure his reputation and that the statements referred to him. Statements were presumed to be false. The New York Times and the civil rights leaders could not use the defense of truth because there were some factual errors in the ad. So the Alabama officials believed this was a great opportunity to use libel law to destroy the New York Times and the Southern Christian Leadership Conference. So the statements in the ad were generally true, right? The Southern officials had been complicit in violence against the protesters, although maybe not all of the specific acts that they were accused of. L.B. Sullivan and 3 Montgomery officials each sued the New York Times and the 4 civil rights leaders for $500,000. Governor Patterson then sued the Times and the 4 civil rights leaders and Martin Luther King for $1 million. And By 1963, the New York Times and the civil rights leaders faced $3 million in damages in 5 libel suits that were brought over this ad. A bunch of officials in Birmingham, including the notorious Bull Connor, who you see here, then sued the New York Times for over $3 million because the Times was reporting unfavorably about civil rights events, he believed civil rights events taking place in Birmingham. So these lawsuits were clearly being used to punish the New York Times for its civil rights reporting and its pro-integration stance. And they were attempting to stifle that reporting by intimidating and burdening the newspaper with libel suits. These lawsuits were also meant to quash the Southern Christian Leadership Conference and to inform the civil rights movement that it would be persecuted if it continued to challenge the status quo. The Alabama officials wanted to let the New York Times and the entire northern press know that they faced devastating libel suits if they covered the civil rights movement, supported integration, ran Martin Luther King's advertisements, or published any criticism of Alabama. So as a result of these libel suits, the New York Times actually faced the possibility of bankruptcy. Never before in American history had there been a coordinated official conspiracy of this magnitude to use libel law to destroy a disfavored newspaper and a social movement. So in a historic move, the New York Times took all of its reporters out of Alabama to avoid further libel suits. The New York Times had no journalists on the ground in Alabama, one of the most important sites of civil rights activity during critical years of the civil rights movement. And many other newspapers contemplated doing the same thing. They didn't want to get sued for libel. And so these libel suits were having a chilling effect on the press. L.B. Sullivan's lawsuit was the first to go to trial. It was heard before an all-white jury in the segregated courtroom of Judge Walter Burgwin Jones. On the day of the trial, a celebration of the 100th anniversary of the Confederacy was taking place in Montgomery. Judge Jones permitted local residents to attend the trial dressed in their Confederate uniforms. Not surprisingly, the all-white jury awarded Sullivan $500,000. That represented the largest libel verdict in history to that time. Shortly after, the mayor of Montgomery won $500,000 against the New York Times and the civil rights leaders. Noted the Chicago Tribune, even the most intrepid publisher must be intimidated into silence. So these victories spurred copycat lawsuits. Officials on the South got on the bandwagon and filed libel suits against many other news organizations over their civil rights coverage. By 1964, Southern officials had brought 17 libel suits against media outlets seeking damage awards of more than $288 million. Now, the Southern Christian Leadership Conference was hemorrhaging money in the defense of these libel suits. The organization could not progress in its important projects like sit-ins and freedom rides and voter registration campaigns if its leaders were saddled with massive libel judgments and these defensive litigation battles. The Alabama officials had sued the most prominent leaders of the civil rights movement. Ralph Abernathy was pastor of Montgomery's First Baptist Church and a leader of the Montgomery bus boycott. Joseph Lowry, who was a pastor in Alabama, had also helped lead the Montgomery bus boycott. Fred Shuttlesworth, who is in the middle, he was the outspoken pastor of the Bethel Baptist Church in Birmingham, and he held the record as the most jailed civil rights leader. He had been beaten by mobs and imprisoned for his efforts to desegregate Birmingham. In one of the cruelest episodes that I describe in the book, the Alabama authorities actually took away the minister's property to pay these libel judgments. So they hauled away Lowry's old Chrysler and Shuttlesworth's 1957 Plymouth. Martin Luther King described the libel cases as a civil rights crisis. He said the libel suits had become a new and potent weapon in the arsenal of the segregationists. So predictably, the New York Times and the ministers lost their appeal to the Alabama Supreme Court. The ministers decided to appeal to the U.S. Supreme Court. The New York Times wasn't convinced that it should appeal. It didn't think it had a chance of succeeding because the law really wasn't on its side. So we're now talking about the Warren Court, right? So the Warren Court at this time was not yet a reliable guardian of freedom of speech, although it was an ardent defender of civil rights. The New York Times had an established policy of not settling libel cases. As a rule, it didn't want to settle because it didn't want a reputation for being an easy target for libel suits. But the Times was actually tempted to settle this case. And the Times had a lawyer at the time who was named Louis Loeb, who was a very proper, kind of conservative gentleman. And Loeb really didn't want to subject his client to undue risk. It was actually Loeb who had made the decision to take the reporters out of Alabama. And yet Loeb saw the long-term risks if the New York Times did not appeal this judgment. He said, if the New York Times settles this case, who else is going to come along and sue the newspaper for millions? Would the segregationists in the next round of libel suits try to sue the New York Times out of existence? He believed there was an important issue, a principle here. He said if Sullivan's verdict were sustained, the media might be forever restrained in its reporting on civil rights. So Loeb convinced the leaders of the New York Times that they had to appeal to the U.S. Supreme Court on the grounds that libel laws like Alabama's, which were very strict, very similar to many states' libel laws, those laws impaired freedom of speech and press. And so the Times gave Loeb permission to go forward with this appeal. And Loeb called up a very famous law professor named Herbert Wexler, who was teaching at Columbia Law School, probably the most famous law professor of his time. He had argued many cases before the Supreme Court, served in the Department of Justice, had written very important law review articles. And Loeb believed that there was a chance that the court might alter libel law. He described to the New York Times how First Amendment law was evolving, and he said, we've got to take a chance here and try to convince the Supreme Court that libel law raises a First Amendment issue. And so Wexler's strategy was to shift the main issue in the case from the right to protect individual reputation to the right of citizens to criticize government and its officials. So in the Supreme Court, Wexler makes the sweeping argument that there is an unconditional right to criticize government and its officials. He argues that criticism of public officials is protected entirely by the First Amendment, even if the statements are false and defamatory. So that was a pretty bold argument. Knowing that argument wasn't likely to succeed, Wexler offered other reasons why Sullivan's judgment was unconstitutional. He pointed out that the ad didn't mention Sullivan by name. There was really no injury to Sullivan's reputation. And in passing, Wexler proposed a version of what eventually became the rule in New York Times versus Sullivan, the actual Malice rule. In 1963, the Supreme Court voted to hear this case, New York Times versus Sullivan, and it's not difficult to figure out why the court decided to hear the case. This libel attack on the press and the civil rights movement represented another example of Southern intransigence and resistance to the court's integration mandates. The justices were all aware of the slew of libel cases that were coming up from the South and their chilling effect on news coverage of the civil rights movement. The justices considered the petitions of the Times and the ministers as newspapers and television screens featured images like this of protesters, including young children, being blasted by fire hoses and attacked by police dogs in the streets of Birmingham. So the Supreme Court engaged with this case out of concern for the civil rights movement, clearly. But it was also concerned with the free speech issues at stake. So the relationship between libel and the First Amendment was an important issue that the Supreme Court had not really dealt with to that point. So the oral arguments were scheduled for January 8th and 9th, 1964. Roland Nachman, who was the lawyer for L.B. Sullivan, flew from Montgomery to Washington to argue the case. And as he was leaving, he told L.B. Sullivan that he was certain that they would have a, quote, bomb-proof victory. He said, either we will win, or they, meaning the Supreme Court, will change the law of the land. which of course is exactly what happened. The Supreme Court changed the law of the land. The austere and orderly setting of the U.S. Supreme Court was a far cry from the violence-laden streets of Birmingham and Judge Jones's courtroom in Montgomery. None of the sectional conflict and racial animus that had brought forth the case were apparent when the 9 justices proceeded through the red velvet curtains into the ornate marble-walled courtroom and sat down in the high-backed chairs behind the mahogany bench. Herbert Wexler made his argument for absolute protection for criticism of public officials. Roland Nachman presented the case as an ordinary libel case that had been tried under well-established rules. The lawyers for the civil rights leaders told the justices that the central fact of this case is that the ministers are being punished because they had the courage to speak out in the struggle to achieve rights guaranteed by the Constitution for all citizens, regardless of race or color. So the Supreme Court justices heard the arguments, and then they met at their weekly conference to discuss the case. All of the justices were clear that L.B. Sullivan's judgment had to be reversed. But the grounds for reversal were a matter of debate. So there were 2 justices, Hugo Black and William Douglas, and they had a very broad reading of freedom of speech. They believed that the First Amendment protected speech absolutely, and they supported Wexler's broad argument. But the other justices weren't willing to go that far. They believed that there should be protections for reputation, and that the right of reputation should be balanced against freedom of speech. But how to strike that balance was unclear. Chief Justice Earl Warren asked Justice William Brennan to write the opinion in the Sullivan case. And Warren often did this. He turned to Brennan to write opinions in high-profile cases where the justices were clear about the result that they wanted to achieve, but they didn't exactly agree on how to get there. And Warren often turned to Brennan for this because Brennan had a really gregarious personality. He was well known as a negotiator and a unifier. He was able to bring the other justices together. And Warren also knew that Brennan had a very strong commitment to civil liberties and civil rights. And so Brennan worked on this opinion in early 1964. He worked on it quickly. There was a lot of time pressure. Brennan knew that this situation in Alabama required swift resolution, given the drain on the New York Times and the civil rights movement and all of these other libel cases coming up from the South. And so Brennan wrote several drafts of the opinion in which he developed the main rule of the case, which I mentioned is actual malice. And so actual malice is a legal term that's a little bit misleading. Brennan later regretted that he chose this term actual malice because malice suggests spite or ill will, right? But under Brennan's actual malice rule, a public official can recover damages for libel only if the official can show that the defamatory statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. So this means that the speaker must have strong reason to believe the statement is untrue, and they go ahead and make that statement anyway. So reckless disregard of the truth. So that rule was used to strike down the judgment against the Times and the civil rights leaders. On March 9, 1964, Brennan announced the unanimous opinion reversing Sullivan's judgment. He said, "We hold that the rule of law applied by the Alabama courts is constitutionally deficient for failure to provide the safeguards for freedom of speech and of the press that are required by the First and 14th Amendments in a libel action brought by a public official against critics of his official conduct." So the urgent situation in Alabama had called on the Supreme Court to take a fresh look at an entire area of law and to re-examine the principles and values of the First Amendment. So the opinion went on to announce the actual malice rule. And with it, the Supreme Court radically shifted the balance between the protection of free speech and the protection of reputation. Now, the actual malice rule did not eliminate the law of libel by any means, but it did create a substantial hurdle for public officials to overcome when they sue for libel. Brennan wrote that the old rules of libel had a chilling effect on free speech because they produced self-censorship. Brennan recognized that under the actual Malice rule, there might be times when someone really was defamed and they wouldn't be able to recover for that defamation because the statements were not made with reckless disregard of the truth. He said, well, that's the price that we have to pay for freedom of speech. He said, erroneous statement is inevitable in free debate, and it must be protected if the freedoms of expression are to have the breathing space that they need to survive. And this is one of the most controversial parts of the Sullivan opinion. As one scholar put it, Sullivan protected falsity in order to protect the truth. Even more important, though, was Brennan's vision of the First Amendment. So Brennan announced for the first time a, quote, central meaning of the First Amendment, which he defined as the ability of citizens to criticize government and its officials. And this freedom was part of what Brennan famously described as America's, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. This was one of the most forceful and extensive articulations of the role of freedom of speech in democracy. And that statement transformed First Amendment law and theory and the nation's experience with freedom of expression. So the Supreme Court saved the New York Times from potential ruin. The decision not only reversed L.B. Sullivan's judgment, but it turned back the entire libel attack that was being waged by the segregationists. This decision freed the press to report fully and freely on the civil rights movement, coverage that could have been undermined if the next wave of libel suits had gone through the courts without Sullivan's protections. So after New York Times versus Sullivan, media coverage of the civil rights movement was indeed robust and wide open. Reporting on protests in Selma, Alabama, the following year helped to facilitate the national consensus on civil rights that led to the Voting Rights Act of 1965. So insofar as the success of the civil rights movement can be attributed to direct action protests and media coverage of those protests, Sullivan was one of the more important Supreme Court decisions facilitating the advance of the civil rights movement. New York Times versus Sullivan freed the civil rights movement from the burden of defending the libel suits. The phrase uninhibited, robust, and wide open has been quoted in more than 60 Supreme Court opinions to justify the protection of free speech in a variety of different areas. With its declaration that freedom of speech is foundational to democracy, Sullivan really became the basis of our modern First Amendment law. Brennan's language became important not only to legal doctrine, but also to our free speech tradition. I think the way that Americans have come to understand the meaning of freedom of speech. The political theorist Alexander Meiklejohn called Sullivan an occasion for dancing in the streets. But not everyone was dancing in the streets. Sullivan was highly contested in 1964, and it remains contested for the broad protections that it gives to speakers, including the press. Now, importantly, Sullivan does not protect the press only. It protects all speakers, although the press historically has been the most frequent defendant in libel cases. New York Times versus Sullivan led to a sea change in press practices. It enabled the press to take on reporting on public affairs without fear of devastating libel suits. Now, of course, the press still gets sued for libel, but it's less likely to lose. And the kind of large-scale libel attack that we saw in Alabama in the 60s is really no longer possible as a result of New York Times versus Sullivan. Importantly, New York Times versus Sullivan facilitated investigative reporting. I think disclosures about the Vietnam War and Watergate might never have happened if the press lacked the shield of New York Times versus Sullivan. So Sullivan has played a very important role in allowing the press to report on official corruption. However, there are some who claim that New York Times versus Sullivan led to irresponsibility in journalism. They attribute the rise of tabloids and gossip in the media and talk radio, for example, to the actual Malice rule. There are some who have attributed the spread of misinformation to Sullivan. Some have said that the court just didn't give enough weight to the important value of reputation in the Sullivan ruling. And this criticism that the Supreme Court failed to protect reputation became even stronger in 1967, when the Supreme Court began to apply the actual malice rule to libel cases involving public figures. So Sullivan dealt only with public officials, but in 1967 the court said the actual malice rule applies to public figures, and it defined that category very broadly. So a public figure is anyone who gets involved in public life, even in a minor way. It could just be by commenting on a public issue or engaging in a protest. And so as it stands, this ruling applies to a broad range of libel plaintiffs, and I'll say more about that in a moment. Sullivan has been memorialized as a case about the First Amendment. All law students read this in the context of studying freedom of speech. The civil rights dimension of the case tends to be obscured. And I think that has to do in part with the fact that the court really didn't mention civil rights in its opinion. Warren and Brennan really wanted a broad ruling that would protect freedom of speech beyond the civil rights context. But I don't think anyone who was around in 1964 could have ignored Sullivan's relationship to the civil rights movement. I mean, this case was clearly the product of the marches in the streets in Birmingham and the product of the freedom rides and Bull Connor's attacks on protesters. I think Sullivan was really a vindication of a growing public consensus in favor of civil rights. And the Supreme Court's ruling, I think, reflected that public consensus and reinforced it. So New York Times versus Sullivan was one of several cases in which the Supreme Court strengthened the First Amendment in order to protect the civil rights movement. So through First Amendment cases involving the civil rights movement, the Supreme Court began developing a body of free speech law that was strongly protective not only of civil rights activists, but all dissenters, protesters of every kind. In recent years, New York Times versus Sullivan has come under attack, and there's really been a big movement that has been criticizing Sullivan and calling for the Supreme Court to overrule this decision. Now, the familiar criticism of Sullivan is that it does not provide enough protection for reputation. Some say it's too hard to demonstrate reckless disregard of the truth. So some people who have really been defamed, who have really experienced reputational harm, will not be compensated under the law. They say that's a problem. Some have argued that social media, right, with its power to disseminate harmful statements on a mass scale, requires that we have a stronger law of libel, right? We need to deter defamatory attacks online and give people a chance to recover for severe harms to their reputations. And so some critics of Sullivan have made this argument. They argue that democracy requires not only a freedom of speech, but also the protection of civility and interpersonal respect. And they've argued that defamation laws that are too weak may actually harm democracy, that we may actually be benefited by stronger defamation laws. So that's one criticism that's come up in recent years. Other critiques of Sullivan include the originalist critique. So originalism has become an increasingly popular way of interpreting the law, and according to the originalist critique, Sullivan has no basis in an originalist reading of the First Amendment. So the originalists have argued, well, at the time of the framing of the First Amendment, the law of libel was actually very strict. And the framers of the First Amendment had nothing like an actual malice rule in mind. So that's been one rising critique of Sullivan, the originalist critique. Another argument that's been given for overruling Sullivan has to do with misinformation in the social media age. We are awash in misinformation, and some critics say that the weak law of libel has contributed to this. And they've argued that one way to diminish misinformation is to change the law of libel, to make it easier to punish falsehoods. And this argument was actually publicized in an opinion, a dissenting opinion written by Justice Gorsuch in 2021. The Supreme Court decided not to take a case revisiting Sullivan, and Gorsuch said that the court needed to do that in part because of this misinformation problem that we're now facing. Personally, I don't think these critiques are valid. Herbert Wexler's argument before the Supreme Court was actually an originalist argument. So Wexler said that the framers of the First Amendment, maybe they weren't actually thinking about actual malice, but they were thinking about a broad right to criticize public officials, right? That the essence of democracy is the right of citizens to comment on their leaders and to hold them accountable. I think it's true that social media have intensified threats to reputation, and I think there's a lot of misinformation online. But I'm not sure that changing New York Times versus Sullivan is going to remedy the misinformation problem. In part because most of the people who are putting out this online misinformation are not going to be deterred by libel suits. So the guy who's sitting in his basement tweeting out defamatory statements probably doesn't care about libel law because he wouldn't be able to pay a libel judgment, and the law of libel is not going to affect his behavior whatsoever, right? And libel law deals only with statements that are defamatory, statements that injure a person's reputation. Libel law does not deal with general falsehoods. So if you say, the world is flat, that doesn't impugn anyone's reputation. So libel law is not going to apply to sort of a generic false statement. And importantly, false speech is protected by the First Amendment. The Supreme Court has said that, even blatant untruths are a form of protected speech. So I don't think that New York Times versus Sullivan will be overruled anytime soon. It's generally considered to be canonical and foundational to our First Amendment law. I think that if the Supreme Court is going to modify any aspect of the constitutional law of libel, it will be in the extension of Sullivan's actual malice rule to public figures. I think the court may redefine what a public figure is. So as I mentioned, it doesn't take much to be considered a public figure today. The law says that if you put yourself into any controversy or any sort of public issue, even a minor issue, you are a public figure and you have to show actual malice in a defamation suit. So again, if you comment on something on your blog or if you go out in public and protest, you've put yourself into a controversy and now you're a public figure for the purpose of defamation law. And so some critics have said, well, this definition is so broad, again, that you will actually deter people from getting involved in public life because they're going to be public figures and they'll have less protection for their reputation under libel law. And so I think that if there's any aspect of this legal regime that the court alters, it will be in narrowing the definition of who is a public figure. Maybe saying that public figures are only those who are true celebrities or household names, not just the ordinary person who happens to get involved in a political issue randomly. So it should be pointed out that American libel law is not strict, but it's not dead, as some critics claim. For example, we've seen a number of high-profile cases in recent years where plaintiffs have prevailed on their libel claims. Dominion Voting Systems received $787 million from Fox News over Fox's defamation of Dominion when it repeated statements that Dominion had engaged in election interference. Fox News apparently repeated these statements knowing that they were not true, and that is reckless disregard of the truth under the law. There were two election workers who won a libel suit against Rudy Giuliani over his false statements that they were tampering with votes. So it is possible to recover in a libel suit if there is an intentional falsehood, if there is reckless disregard of the truth. So I think that the courts have struck a balance between freedom of speech and reputation, a protection of reputation that has actually served us pretty well. So our public discourse since 1964 has been free, uninhibited, robust, and wide open. The American system of freedom of expression is really exceptional. We are largely free to express our views, even if some may find those views repugnant. We're free to protest, to demonstrate, and to question. And I think New York Times versus Sullivan had a lot to do with that. The law and culture of freedom of expression that Sullivan helped bring about has brought with it tremendous benefits and also many challenges. So I hope in this talk to have shown how the landmark decision in New York Times versus Sullivan played a critical role in shaping freedom of speech, journalism, and American society since 1964. The story of New York Times versus Sullivan illustrates how constitutional law develops from the intersection of facts and real-life situations with broader social issues and concerns. So in this case, events and conflicts growing out of the civil rights movement produced major changes to an established area of law and yielded one of the most important articulations of the meaning of freedom of speech in American history. That articulation was perfectly tailored to its times, and yet it continues to have enduring significance. And so with that, I will turn it to you to questions and comments. So thank you very much.
I think what you said is extremely interesting, but I think you started to go into the fact that social media is killing people.
Right.
I have a lot of friends who would run for public office or whose children would run for public office, and they're absolutely afraid to even do it because something that happened to them 10 years ago will come up and hurt their family. So one question with that, and then I'll couple it with what's going on, the protests in whether it's Minnesota or New York City or whatever it is, whether it's against ICE, whether it's against the Jews, they've just gotten so out of control. How do you see legally this being resolved between what is moral and what is in the First Amendment?
Mm-hmm. Yeah, so there are many very complex issues that you've raised, but on the first point about people, being too afraid to enter public life because fear that they'll be defamed without recourse. That's been one of the main arguments in favor of overruling Sullivan. There are some who have argued that we actually need to have stronger defamation laws to protect democracy because we want good people running for office, right? We want, if we have a regime where people can be smeared without any recourse, we'll get the worst people running for office rather than good people who actually care about their good names. So I think that's an important argument, and we see that increasingly.
What can be done about it?
Yeah, well, of course, there's changing the law of libel, but I think that's an extreme solution. There is a law called Section 230 of the Communications Decency Act of 1996. I don't know if you're familiar with this, but this is a law passed by Congress back in the era when the internet was just developing. And this law provides broad immunity for internet service providers. So if someone defames you on Twitter, you might be able to try to track down that person and sue them, but you can't sue Twitter. So all the platforms are completely immune. All the websites are immune. And some have said that has led to complete irresponsibility online. And if we want to try to restore civility and stop these attacks on people, we need to start holding the platforms accountable. But that's not a matter of constitutional law. That's a statutory law. And there's been a lot of there have been a lot of good arguments that Congress should repeal or modify Section 230 in some way. So that's kind of beyond the scope of what I talked about, but there are potential legal solutions to what you're talking about.
It's a very interesting talk. Thank you. I wanted to ask you, to what extent, if any, do you think the Me Too movement is sort of an ultimate result of the Sullivan decision? And I think about politicians I've seen who've been accused by women of sexual harassment, and the presumption in many circles is that they must be telling the truth. And I'm not thinking about the president. I'm thinking about Andrew Cuomo, the former governor of New York, where individual after individual, woman after woman, leveled accusations against him with no proof. He's suing at least one of them right now, but it's been years going on, and the defense is in part that he's a public he was a public official.
Mhm.
He was run out of office.
Right.
But if it wasn't for Sullivan, it seems to me he would have had a stronger defense.
Yeah, and I think that's, goes back to the idea that public figures can be besmirched unfairly with little recourse. One other kind of dimension of that, though, is that the people who speak out to criticize public officials under this public figure doctrine, now they have to show reckless disregard of the truth, right? If somebody now accuses them of lying, so now we've got, defamatory harms going in all directions. So I think that is actually maybe a deterrent to people speaking out, right? Because then if they become public figures, then they're not going to have a lot of protection for their reputations if they're accused of being liars. But I don't know, I'd be curious to hear actually what you think the remedy is for this problem, because we've got important issues on both sides of the equation, right?
Yeah, it seems to, oh.
I don't have an easy.
Okay, you don't have a solution.
The law profession.
Okay, yeah.
Generally, we're all liable now. If I walk across the room and I say something that offends somebody, we're all liable. I think this is the biggest thing that I've noticed. I'm a journalist, I'm a professional journalist. I was a professional newswoman. And I was 16 in 1964, and I worked for Tex McCrary, who, I started in radio and television, so what you were hitting was all these nerves. And it's hitting all our nerves, because we all remember 1964. Where we are now, you, me, we're all afraid to talk.
I'm not.
No, well, I'm not. Look at me talking. But I think, Jeff.
If we insult someone, how are we liable? You said we're all liable. How? I don't think the law professor would agree.
Well, that's what I want to say, because it's all fudgy right now. Because we're all under attack. And we can go to the professional side. If I did the wrong thing as a news person, and we're supposed to study journalism law, how we interview people and the rules. But it's such a free-for-all now. Bear with me. I'm not making any point other than a general point. That we're all in this huge new experiment where we can say anything we want, and the TikTok this, and the TikTok campaign, and the this, and the this, and the this, and the social persuasion. Anybody, I was just telling my friends here, I was scared to go on Facebook because it's the Wild West. But it's like there's so much happening with this new phenomenon, 25 years of electronics and social media. The Pandora's box is open, and we're getting information instantaneously all over the world. And we're seeing hopefully the peace process in Rwanda. We're seeing this. We're seeing people take chances. We see abuse. Our kids have seen so much in the last 25 years. Our children grew up on it, and they've seen everything. I'm talking a little long, but I see that we have to be careful, because all of us are afraid to speak.
I'm not afraid to.
No, but I'm speaking, but that's the point. We're all speaking, and we're all out there, and we have to have courage. Whether we run for office or go to the ladies' room, wherever we go, we have to have courage. I'm sorry, I talked a little long.
I wanted to ask, if I could, a second question that's unrelated to the first one. And that has to do with, it seems to me, a contradiction in the law, which I'm sure you're certainly familiar with, and that is the shield laws in many states that protect journalists from, in civil actions mainly, from having their notes or other records subpoenaed. But if there's a civil action for libel or slander, and I can hide my notes, which might reveal that there's malice, how do those two laws come together?
Yeah, that's a great question, and I think that some courts have actually been saying that if a sort of threshold can be met and there's a legitimate libel case, then that confidentiality can be abridged. What?
It trumps the truth.
Yeah, right, yeah, in certain libel cases. But that's kind of a developing area of law, but I agree there's a real issue. You know, there would be no cause of action for libel if all the evidence was shielded by these laws. So, yeah, good question, thank you. Yeah.
I have a question, because somebody was just saying to me earlier that there was an article in the paper, there was an article in the paper today about a woman who posted some things on Facebook against the mayor of Miami, and she had two people, two agents showed up at her house, accusing her of this, and she said, she wouldn't speak without her lawyer. But what is, and I would say this is happening, broader than, so what is the recourse for that woman? What if that's me? Like, what are my rights?
Yeah, so that's a very important question. I mean, I think about the different kinds of threats against freedom of speech that we're seeing today. I think our law, the formal constitutional law of free speech, is actually pretty robust. And I think if people want to take things to the courts, they will have a strong chance of winning. So I think our formal law of freedom of speech is not the problem. I think politicians and officials are really bearing down hard on freedom of speech. I mean, they're blocking freedom of speech in many ways, and so we have kind of a political threat to free speech. But something I like to think about in my work is the culture of free speech. I think that in order for free speech to survive, we not only need protective laws and respectful politicians, but also kind of a cultural environment where people feel emboldened to speak out, and where people tolerate others' point of view and welcome diverse opinions and are receptive to hearing things that may not be in line with what they personally believe. And I think one of the greatest threats to free speech that we're facing today is in the culture. Right? We don't have that sense of openness and tolerance and willingness to foster discussion and to have these debates. And free speech can't survive in an environment of intolerance. Even if the laws are completely protective, if we don't have that cultural ethos, then free speech is just not going to be a reality. So I think, what we can do, we can we can speak out against these abuses. We can protest, we can write things in the media, we can make art, we can refuse to support officials that violate free speech. And of course, the courts remain a forum for recourse. Yes?
I guess the question what other people have talked about is like the fact that a viewpoint of disinformation, let's say, what you would think would be libelous, could actually become hugely popular view, right, to the point where it's considered fact. The perception is so massive because of social media and everything. And my understanding is the only recourse would be damages. So you would actually have to prove damages, like either a loss of income or material loss or something. Is that the case?
Yeah, so libel only applies in situations where a person's reputation has been harmed. And so if the person can show that the statement was false, that their reputation was injured and they've lost something because of that, and that the statement was made with reckless disregard of the truth, then they would be able to recover a damage award. But as I've suggested, those are very difficult hurdles to clear. So it's not easy to recover for libel in the US compared to many other countries, right? England has a very robust libel law, and it's incredibly easy to recover, and really in most other parts of the world. But the US has this exceptional system, unique system, in part because of the events I described, the civil rights movement, the anti-war movement of the 60s, the particular composition of the Supreme Court. It just created a very unique system. And so it's possible, but difficult to recover in your situation. Yeah.
What is the libel rules like in the UK? This morning there was an article in the paper about Prince Harry trying to sue the paper Are they stricter or not stricter or what?
Yeah, so libel laws in Britain are essentially, what the U.S. laws were like before New York Times versus Sullivan. So as I was describing, falsity is presumed. The burden is on the defendant to prove the truth. There is no protection in the form of an actual malice rule. And so I think it's very dangerous for news media to criticize public officials in the UK and elsewhere because there's quite a bit at stake and they don't have a First Amendment and those constitutional protections. And some public officials and celebrities actually go to England and bring their libel suits there because it's a lot easier to win than in the United States. Yeah, thank you.